Dear friends, this is the second video of Criminal Procedure Code. In this video, we are telling about the hierarchy of criminal codes. In the hierarchy of criminal court, the Supreme Court is the apex court, is the topmost criminal courts in the country, that is in the Union of India. India, Bharat is considered as the Union of India according to the Constitution of India. And the High Court is the second criminal court in the hierarchy of India. And over 1,610 judges and in 25 high courts in India is now established. The Sessions Court. After High Court, there are Session Division and Session Courts are there in the territory of India. The Session Judge, Additional Session Judge are there in the Session Division. Additional Session Judge have same power and same category of Session Judge. It is, if there is an assistant session judge is the below the rank of a session judge or additional session judge. The session judges and then chief metropolitan magistrate. If there is a metropolitan city, Delhi, Bombay, Calcutta, like metropolitan city, there are chief metropolitan magistrate are there. If it is not a metropolitan city, there is a chief judicial magistrate are there and additional chief judicial magistrates are also there. In the chief metropolitan magistrates, there are two subdivisions are there. Additional chief metropolitan magistrate and chief metropolitan magistrate have the same rank, and then it is subdivided into metropolitan magistrate and special metropolitan magistrate. So, chief metropolitan magistrate and additional chief metropolitan magistrates are divided only in two categories, metropolitan magistrate and special metropolitan magistrate. Thereafter, we will deal about additional chief judicial magistrate. In the hierarchy of a district, chief judicial magistrate considered have exercised the jurisdiction overall in the district. And for the suitable functioning of our judicial system, chief judicial magistrate are again subdivided into additional chief judicial magistrate. Chief judicial magistrate and additional chief judicial magistrate have the same rank. Then subdivisional judicial magistrate. Subdivisional judicial magistrate is again classified into two categories. In below there are two categories, judicial first class magistrate and judicial second class magistrate. Judicial second class magistrate is considered as the petty magistrate. That means they are collecting petty for the small offences. Next topic is power of the court. Power of the court. Section 26 of the Code of Criminal Code 1973, as amended by the Criminal Law Amendment Act 2013 with effect from 3 to 2013, that there is an important point that the last amendment in Criminal Procedure Code is done in 2013. That is an important point. Not only that, the date is also important point with effect from 3 to 2013. And that provision, section 23, clearly says that gives a list of the code which has offences are triable, and it is reads as follows. Section 26 code by which the offences are tried. Subject to the other provisions of the code. In criminal procedure code there are numerous provisions, and considering and other provisions also, any offence of Indian Penal Code triable by High Court. Usually High Court are considered as an appellate court, it is not a trial court, but in exceptional circumstances High Court can trial some matters. The Sessions Court. Session Court can try the session offences, and 3. Any other by which such offences shown in the first scheduled to be triable. There is a scheduled, the last of the criminal procedure code. In that first schedule, the offences are classified into triable by which magistrate, or which court, or session court, or bailable, or non-bailable. In this type of classifications are in the scheduled. I will explain the scheduled there after this class, and I will explain in the next video. Provided that any offence under the section 376 and 376A and 376B and 376C and 376D of the and 376C of Indian Penal Code. 376 normally you know, that is punishment of rape related offences. 375 is the rape, 376 is the punishment of rape. And of the Indian Penal Code shall be triable as practical by the court presided over by a woman judge. So 375 is the offence of rape, and 376 is the punishment of rape, and 376 A, B, C, D, E are the sexually related offences. So the victim is usually a woman, so that offence is practicable proceeded by a woman judge. The woman judge must proceed, if possible, in this matters for conducting trial. Any offences under any other law shall, when any court is mentioned in behalf of such law, be tried by such court, when no such court has been mentioned, may be tried by the High Court. In the first schedule of Criminal Procedure Code, in each and every offence punishable under Indian law, the offences are classified as bailable offence and non-bailable offences, and which court must try these offences, how many years of punishment shall be enforced. Those details are arrayed in the first schedule, and that is called any offence under the law shall, when any court is mentioned on behalf of such law, be tried by such court. The first schedule says that which offence tried by which court, and when no such court is mentioned, be tried by High Court. That specific court is not mentioned in the first schedule, that case triable by the High Court of that particular state. Any other court by which the offence is shown in the first schedule to be triable. If a separate court is mentioned there in the first schedule of Criminal Procedure Code, that court alone try that matter. Friends, if any doubt or any suggestion for this video, you can comment in the comment box. I will reply as early as possible. Thank you.